Matt Day here with Parsons Graham and Day, and want to take a second to talk about modification actions in divorce or custody proceedings. So there are different types of modification actions. Obviously, you can be trying to modify legal custody, the decision making. You could try to modify visitation. You could try and modify child support. Interestingly enough, each of those has a different standard, and for some of them, like legal custody, there are a couple different standards that are applied even within that category. So let's take a look at child support. So you want to modify child support. You need to know what your burden of proof is on a modification, or what are the grounds that would allow you to modify a child support order. So when wanting to modify a child support order, Title 43, Section 118I sets out that anytime there's a substantial and permanent material change in circumstances, right? So things that fall into that category under that statute would be things like an increase or decrease in income, exercising or not exercising, more or less of the overnights. So anything that changes that has an impact on the child support computation, and frequently that is going to be related to income or overnights. Most of the time, your original order will warn either party that exercising or not exercising your overnights could result in a modification of child support to reflect what's actually being done, right? So if you want to change visitation, right, different than child support, visitation is a best interest of the child standard, right? So under the Robinson case, it sets out that rather than looking at substantial permanent material change, you can look at what's in the best interest in determining visitation schedules. And there's some statutory authority for that under Title 43 as well, so that a court can look at how much time a child is spending, or the children are spending, with each parent, and determine what schedule suits the needs of the children at really any given moment. So best interest of the children is more time, less time in their best interest, right? And then if we look at legal custody, as I said a moment ago, there's a couple different standards. So if you are in a situation in which the other party has sole legal custody, and you want to modify that either to give yourself sole legal custody or to move from sole to joint legal custody, you're going to be under what's called a Gibbons standard. Gibbons v. Gibbons sets out that there must be a permanent substantial material change in circumstances directly related to the best interest of the children. Now, it's not simply that you as the non-custodial parent have made improvements and therefore there's been a substantial material change on your side. The material and substantial and permanent change actually has to be with the custodian, right? So if we're going from sole to joint, sole to sole, we need a Gibbons standard, substantial permanent material change in circumstances. What if we have joint custodians and somebody or both of them want to get out of that joint custody plan? Then we're under a Daniels standard, okay? And that is essentially when the joint custody plan is no longer functioning in the children's best interest. Things that the court's going to look at is, have the parties been able to communicate? Are they mature enough to let go of the past and focus on what's in the children's best interest, right? So a different standard when we've got two joint custodians and one of them or both of them are trying to terminate that. Right. So those are the different standards that are employed in the custody, visitation, child support portion of divorce or custody cases. Right. If you find yourself in a situation in which you need to modify your existing order, or the other party has asked to modify the existing order, give us a call today, 918-307-1529. We'd be happy to talk to you about your matter, strategize, help you come up with a plan. www.pdtulsalaw.com.
The purpose of this video is to be informative and not to provide legal advice. For legal advice, call a law firm and speak to an attorney about your particular case. None of the information provided in here is meant to establish the attorney-client relationship between Parsons Graham and Day and anyone watching this video.